Good afternoon, ladies and gentlemen, and very warm welcome to today's webinar, Reforming Today for a Resilient Tomorrow. We are delighted to have all of you with us as we unpack the Companies Amendment Act number 12 of 2025 and its implication for businesses, compliance, governance in Sri Lanka. Let me begin with a reminder from one of the most iconic cases in corporate law, Salomon versus Salomon. In 1897, this case has established the principle of corporate personality, the veil that separates the company from its shareholders. It was a foundation for corporate supremacy, allowing company to have independent legal person and from their owners. Yet, as time has passed, we have learned that a veil is not absolute. Around the world, the demand has shifted from mere corporate supremacy to transparency and from shielding ownership to accountability. Sri Lanka is no more exception. With the Companies Amendment Act number 12 of 2025, we are standing at the threshold of new chapter in corporate law. One that emphasizes beneficial ownership disclosure, compliance, governance reform. So basically, this is not just a legal shift, it's a cultural shift for businesses, regulators, and market. To guide us through this reform, we have the panel of the distinguished experts, Dr. Harsha Cabral, Ms. Shivandini Liyanage, Ms. Shama Hashini. Our keynote speaker this afternoon is an eminent figure in corporate law and governance. Dr. Harsha Cabral is a President Counsel with decades of experience in commercial and corporate law. He currently serves as Chairman of the National Savings Bank. He continuously served as the independent director of the several boards. Dr. Harsha Cabral has contributed law reform initiatives, including development and strengthening company law, securities regulations, and governance standards. A respected academic and author, Dr. Cabral has written so much in company law and related subjects. He continuously plays as a role model for the next generation of legal professionals. We are honored to have you with us today, sir, and we want to hear from how Companies Amendment Act going to impact the business and reform landscape in Sri Lanka. Over to you, sir.
Good afternoon to everyone. Thank you for those kind words. Well, today we will look into the aspects of the Companies Amendment Act 12 of 2025, which came into being on the 4th of August 2025. And this deals with especially a particular topic called the beneficial interest of shares, which is the main feature of this particular amendment. Besides, we have a whole lot of other amendments which were in the pipeline for a long period of time from 2007 onwards, and a series of typographical errors that have been corrected in this amendment. Now, after a long period of time, this has come in, but the main focus is on the beneficial ownership of shares. So I have a few slides for you all which you will you can take home and study further, especially the people who are affected by these particular amendments, the company directors of boards of all companies, may it be executive directors, non-executive directors, independent directors, so on and so forth, senior officers of companies, and also the company secretary per se. There are other issues also coming up vis-a-vis the administrator, liquidator, Registrar of Companies, and the regulator, mainly the Colombo Stock Exchange. But hitherto, we will go into the details of this, and prior to that, venturing into that particular aspect of this amendment, I would say why this beneficial ownership matter, which is focused very much today, came into being. It was in 2018, the central bank issued a guideline 4 of 2018, especially for the financial institutions. It was addressed to the CEOs of financial institutions. The caption was Guidelines on Identification of Beneficial Ownership of Financial Institutions. Now, that was the first introduction of that, together with the Financial Transactions Reporting Act 6 of 2006, which culminated the episode of this beneficial ownership of shares. Now, as the lady before me introduced the program, mentioned about the principle of corporate entity, separate corporate existence, and she even mentioned about Salomon versus Salomon and Company. So that is, for centuries, companies have been following this particular mechanism, where once a company is incorporated, you have a veil of incorporation. It's a separate entity. Mr. Salomon could sue Salomon and Company. The same way, once a company is created, we did not worry too much about the shareholders or the directors, because that was another creation of another being. So we have a human being and a corporate body. So, be that the case was earlier, over a period of time, there were exceptions to this rule which gave birth to lifting the veil of incorporation. When do you pierce the veil of incorporation? So it was in exceptional circumstances, starting from the English company law, which ventured into so many other jurisdictions, where in exceptional circumstances you had to lift the veil of incorporation to see who were the actual owners of this company were. Now, that was also another exception to this separate corporate entity business. But however, as time went on, it was important to identify the actual owner. Now, that was due to a couple of issues like illicit purposes. This cover was used. You take cover on a company, and over a period of time, in developed jurisdictions and many other jurisdictions, money laundering, bribery and corruption, insider dealings, tax frauds, terrorist financing, and other so many unlawful activities were carried out by corporate bodies, taking cover of the veil of corporate veil. So that means they were covering, and it was important for bodies to be created to know exactly who the actual owners of these shares are, companies are. So various studies were conducted by the Financial Action Task Force, FATF, the World Bank, the United Nations Office on Drugs and Crime, UNODC, to find ways and means how to capture this money laundering and terrorist financing and so on and so forth. Now, this gave way to a whole lot of major jurisdictions to venture into this area of covering yourself with a name of a corporate body. So it was happening in developed countries, but in 2018, Sri Lanka, initially through the central bank, issued this to the financial institutions, and they even gave a format how to give details. That particular guideline had an annexure appendix 1, which said beneficial ownership of form, declaration of beneficial ownership. Now, that has varied details which would divulge who and what the beneficial ownership is all about. So, this act which came into operation, Act number 12 of 2025, the amendment to this Companies Act number 7 of 2007, primarily deals with, in section 130, from subsections A to J, the fact of beneficial ownership. Now, as you are aware, the idea of this seminar is to ensure that the people who are impacted with this amendment, especially the corporations, the boards of directors, the company secretaries, the officers, senior officers, the regulator, the Registrar of Companies, shareholders, administrator, liquidator, and whoever who has some form of impact on these amendments to understand this better. So, I have structured my presentation in such a way that you have a document to take home, because I know most of these individuals may not want to study the whole act or read it over and over again, but a piece of paper which highlights what their role is and which section impacts you will be of use. Now, world over, even in Swiss accounts, once upon a time, you could have numbered accounts. Now did away with that, and you got to give a name, address, details, how you can find out who the actual owner is. Now, as time goes on, you have realized in most of the jurisdictions, even in the areas in our region, the Asian region, there have been a whole lot of issues with regard to illicit money in circulation by way of companies. So the whole idea of this particular beneficial ownership mechanism is to establish transparency by way of various means, which we will discuss in a moment. Now, before I venture into that area, I would try to touch on the main areas of my slides. I would just show you the key reforms which to the existing provisions of the Companies Act number 7 of 2007. Then starting from the sections I'm going to refer to, that is basically all the amendments have been looked into in detail with regard to the first part, that is I've taken 130, the beneficial ownership section from A to J, and then we have the next one would be the other sections which we will be dealing with, that is unmasking ownership, key amendments to the disclosure laws, which will highlight the other amendments that came in. And I thought I would first refer to that and go on to the main feature a little later, because that is what is more important in this particular episode. Starting from section 4, the amendments in section 4, subsection 2, in the slide you would see. Now these are the other amendments which are coming with so I will refer to the 130 beneficial ownership at the second part, but the first part would be with regard to the minor ones. Now section 4, subsection 4 to subsection 2 deals with single shareholder companies. You need not worry too much about this, because this only brings in clarity. Now I've done another column for you to be very specific, that is for the company, and the timeline is within 20 working days. That is only change that has been brought in there is the change. The first one is the single shareholder company one, is a simple one, that is more clarity to the language in 4 subsection 2. Then the second one is 11 subsection 5, the change of company name, it's a responsibility of the company. Within 20 working days, the earlier it was 10 working days. So that again, a little bit of more freedom given to the timelines. Then 51(1)(a), prohibiting issuance of share warrant to bearer shares, that again to come in line with the beneficial ownership. Then 51(a)(1), duty placed upon existing holders of any share warrant to bearer or bearer share to disclose to the company. Again, the responsibility is on the holders of share warrant to bearer or bearer shares. This again is within 60 days from the Act's effective date. That is, you take 3 months, 62 months from the effective date. Then 51A2 is company to maintain a register as to 51A details. That again the responsibility is on the company. 51A3 is rights of holders share warrant to bearer or bearer share be nullified unless disclosed. Again, holders of share warrant to bearer or bearer share. Then 51A4, holder of share warrants to bearer or bearer shares to convert such shares into registrable form. That again, holders of share warrants to bearer or bearer share. And the timeline is within 60 days from the Act's effective date. Now, 52 subsection 3 brings in removal of filing deadline for reserve capitalization. That again the responsibility is on the company. 206.2 special notice to all shareholders vis-a-vis removal of a director. And you would see this again is brought in to give more flexibility with regard to removal of directors in where the responsibility again is on the director, because the addition that has been brought in is the special notice. The most of the secretaries would know special notice is defined very specifically in section 101(45) of the Companies Act. So this particular section brings in an additional special notice. The earlier one did not have that. That is, the director to be given and shareholders to know what exactly director to come forward. And so that is the 28 days, 15 days, and also the special notice that has to be given. So if anyone wants more clarity on what a special notice is, I would ask you to look at 145, which speaks of special notice. Then the director is given. So this part, 206.2, 206.3, 206.4, much of it was there in the earlier act, but the responsibility is on the secretary. Then 206.4 deals with how to be read out, to the representation to be read out at the meeting, so on and so forth, and when to go to court if there is any misuse of same. Then we come to another important section, 211.1, which 211.1 deals with the age of the director. That is, that again is for more clarity. You know, when a person reaches the age of 70, being on the board, you have to go before the shareholders at the AGM and get the blessings of the shareholders to say that we need this gentleman to continue to be on the board. And there was a language issue, and it had been cleared by adding the term valid till the next annual general meeting. So the person who is appointed, that appointment is valid till the next annual general meeting, and that is for more clarity. Section 211 has been brought in. And then the next one is the 270 and 272. That again is to align with single shareholder company 4 subsection 2 amendment. That's only to come alignment with the 4.2. Then 341.3 is liquidator to send a copy of the accounts and date of the meetings. That again for the liquidator. That is again flexibility. Then 424.2 is again for the administrator to provide with an extension of time, again for the administrator. So that is getting more additional time. Then 471 amendment brings in the new role in the administration, that is with regard to the Registrar of Companies, where inclusion of an additional Registrars General, which was not there earlier. So, and 471.3 deals with incentive allowances to officers of the Registrar of Companies. Those are more administrative matters. Only it will be relevant to the Registrar of Companies and not to any company. So 472 is the appeal to court from the Registrar of Companies. Now, here I must say there is no change to the earlier one, appeal to court from the Registrar of Companies. Except for the English one, there is only a comma that has been changed. A new comma has come in. The removal of a comma in the old act, and the amendment is very clear. But in the Sinhala one, it has been corrected properly, because there was a problem in the Sinhala one which mentioned when you say an appeal from the registrars, any order of the Registrar of Companies to the court, the English one had the correct, said court, but unfortunately in the Sinhala one, it said Abhyachana Adhikarane. So it was a problem in the Sinhala one, because that particular section alone referred to going to the Court of Appeal, which was wrong. So there are a couple of cases also, it had to be clarified, and now the Sinhala one is corrected in such a way that appeal should go to the court, and that court is defined as the Commercial High Court in the interpretation section. Then sections 480, and that again there is a timeline within 15 days from receiving of notice. Then 484A, registrar's power to grant extension for certain acts, that again for the company and the registrar. 487.5 is the re-registration of a company. Now that again is an important section, an important amendment. I mean, these were there in the pipeline for a long time, even after the 2007 Act came into operation. Now, the idea was, the idea in bringing that section in the 2007 Act was, the problem was there were so many dead companies or dormant companies, and the files were maintained by the Registrar of Companies. And also for computerization, we wanted to give a number, and the companies were asked to re-register, and there was a time frame given, and notice was given after about 2 years, I believe, the companies that were not re-registered. So the idea was to get the dead wood out of the way. But unfortunately, there were companies which had missed it, and which had assets in their own companies, which had a problem because they had not re-registered, and the names were struck off. And the idea was, if there were any assets, that to annual to the state. But I believe it did not happen, and this is brought in section 487 amendment, is amendment number 17 of this particular amendment, is to give opportunity to for 10 years from now, that is from before 4th August 2035, a person, you can get your company re-registered and back to force, and if by any chance it has vested in this thing, there are mechanisms that have been brought in. There are 3 provisos, but unfortunately I see a small issue in this particular amendment, because I remember we drafted this amendment long years ago, but somehow it has missed this, the current amendment. It doesn't say who can make this application. According to this 487 amendment, provide that any company of which the name has been struck off under subsection 3 may before the expiry of period of 10 years from the date of operation of the Companies Amendment Act, apply to court. Who can apply, unfortunately, has been left out, because a dead company, any company, when you say a dead company, cannot make an application. The earlier draft we had, I believe, we had any party interested, a shareholder, a director, or a creditor who has any claim to make this application. Unfortunately, I don't see that. Maybe in a future amendment that has to come in, because a dead company can't make an application to the court, because you have to first to re-register who the applicant's issue is not there in 487 amendment. That's a lacuna which has to be looked into. Then we come to another fairly important amendment, when 508 with mediation, this was always there, party to a dispute to request the matter to be referred to mediation before the hearing of the Company Disputes Board. It was there, but it has been brought in with more clarity, where the company, president of the Company Disputes Board, if he deems appropriate, he can refer the matter for mediation to any member of the Company Disputes Board. Other than that, there is no major change that is coming in. Then 513A deals with more clarity on penalties. The penalties have been increased with regard to and who will be liable to pay body corporate, every director, manager, or secretary or such body corporate. If it's a partner, every partner or every member of such body. From 50,000, it has gone up to 1 million, and imprisonment 500,000. So more general penalties have been brought in a more realistic manner. And then the next is, I refer to 529 is the last one in that slide. 529 deals with definition of distribution has been brought in very clearly. The only difference I see with the old one and the new one is becomes the company. A company becomes the company. Other than that, because that again is for clarity with regard to definitions. Then the list of typographical errors, corrections, which were in the pipeline for a long time, whole lot of corrections, and you need not worry. Those are for clarity purposes, which have been brought in for as amendments which were in the pipeline. So I would not call those areas important areas for the parties who are interested. And so now we come to the main part of beneficial interest of shares, which is starting from 130A to J. Yeah, 130A1 is where you find the beneficial. In the slide you would see. So 130 subsection 1A, A1 is beneficial ownership details of a company shall be given to the registrar. Now I have a column to say whose responsibility. It's a company, and timeline at incorporation or 20 working days of issue or transfer of shares. That's no problem. You would know it's very clear. 130A2. Every shareholder shall give the details specified in subsection 1 to the company. So the responsibility is each individual shareholder within 10 working days of the subscription of transfer of shares. Now, before going to any of those, I would take you to the 130J itself, where 130J deals with beneficial owner and effective control. So that is a fairly important one. You will have to look at 130J because all that will emanate from the next one. You would like to look at the definition of beneficial owner to understand the subsequent sections. Now 130J, under this heading, interpretation of beneficial owner. Beneficial owner means a natural person who ultimately owns or controls 10% or more of a company. I emphasize the words 10% or more of a company, in whole or in part, through direct or indirect ownership or control of shares or voting rights or other ownership interest in that company, and also includes a natural person who exercises effective control through other means, and beneficial ownership is to be construed accordingly. Now that is the key feature of all the other subsections. You have to know who a beneficial owner is. So the key is 10% or effective control. Then you define effective control to say effective control includes a situation where control is exercised indirectly, either through chain of ownership or by appointment or removal of a director or by any other means of indirect control, such as the ability to take strategic decision that affects the operation of the company, its business practices or general direction of the company. So these two definitions, beneficial owner and the effective control, is of importance for you to understand what exactly this means. So you would see, now if you go back to 130A1, which I started off with the first part, A1 is no problem. You have to do it within 20 working days, or issue or transfer of shares. Responsibilities of the company. 138.2 is every shareholder shall give the details. So the responsibility is on the shareholder within 10 working days of the subscription or transfer of shares. A3 is shall disclose details of beneficial ownership of the company to the registrar. Now that is where every director or secretary comes into play. When become aware by a director or secretary. Now this is a fair responsibility cast on the board, basically the secretary. 130A4, company shall maintain a register and record beneficial ownership details, that again for the company. Now going forward, you have to now emphasize, these were not there earlier. These are additional responsibility. You maintain your share register. Now here you have another burden. 130A5, company stroke liquidator shall maintain records and details of beneficial ownership. So again, responsibilities on the company or liquidator, and you got to maintain these records. If the company must maintain for 10 years, liquidator must maintain for 5 years, under several other statutes, accounting statutes, your financial details, your other details, there are responsibilities coming on other statutes as well. But here in black and white it says company must maintain for 10 years and liquidator and for 5 years. Generally, once the company is dead and buried, a liquidator may forget about it, but here a responsibility is cast on them to keep them for 5 years. 130A6 shall maintain a register to record details. Now that is cast on the registrar. You will hear more details about the registrar from the expert from the Registrar of Companies, how they shall maintain those register and record details. That's another part of the story. But most of it is the company or a director or a secretary, and very often these, the company secretary's role is to liaise with the Registrar of Companies, because the Registrar of Companies is the repository for all company records. Then 130A7, company shall notify the registrar as to any change in the beneficial ownership. So company, again the registrar will have the company secretary will have to do it within 14 days. If there is any change within 14 days, you have to inform. Then 130A8 shall deliver details of beneficial ownership with annual return. Now annual return is getting bigger by the day. Everything now you have got from this year, you have ESG mandatory coming in. So you will have another additional thing from going forward from this year onwards, where you will give the details of beneficial ownership in your annual return as well. That again is a company responsibility. So 130A9, section 185 of the company shall apply to beneficial owners. Then 130A10, 130J, A to J shall apply to offshore companies. So the 181 is a simple matter, that is with regard to the 130, that is fairly simple with regard to 181, section 181, you will have 138, yeah. So you got to maintain the records, and you will have in section 130 subsection 9 says the provisions of section 181 related to the power of require information as to persons interested in shares or debation shall mutatis mutandis apply to beneficial owners. So that's coming from the responsibility under 181. So same way 138.10 is again, it applies to overseas companies and offshore companies. Same across the board, they apply the same liability. And then 130A11 deals with the definition with regard to former written law related to companies. So that means the companies which are incorporated under the ordinance or the Companies Act of 17 of 1982 will apply. So the next we come to the sections 130B. So 130B is 130B will have the, now it's on the slide. 130B again, it's a responsibilities cast on the company or registrar. Shall make details available of the beneficial owners held or submitted under 130A to public authorities upon request. Now the public authorities, have the right to ask for this information, and you would see under under our present law, the Attorney General, the FIU, Finance and International Unit, then the Director General of Customs, then the Commissioner General of Internal Revenue has the right and details to be established, to be furnished a company or by the registrar. And the word is shall. You can't say you can't. So the beneficial, make available the details of the beneficial owners of the company held or submitted under subsection 130A. 130C, I think the Bribery Commission has already started in most of the cases, and even before this act came into operation. So there are a whole lot of names given specifically. Then 130C is the natural person shall be appointed by the company for the safekeeping and making available details of beneficial ownership. Now, the company must appoint a natural person. Very often this job will be assigned to the company secretary. The company secretary is the one who deals with the Registrar of Companies and this type of maintaining registers and so on and so forth. So the company suggests, now you can't outsource this job. Companies can't give it to another law firm or a audit firm or a secretarial firm to do this particular job, because it specifically says that a natural person has to be authorized, and he or she will have the responsibility, and they must disclose, and that also should be done within 3 months from the effective date. Now 130D is registrar to make details of business beneficial ownership accessible to public and manage RTI applications. A right to information applications can be made to the registrar, which is a public body, and because they can't ask the company, private company. RTI won't apply to a private company, but the RTI will apply to the Registrar of Companies. So when they are asked, the registrar shall make details accessible to the public and to the under the Right to Information Act, and shall make an application. So anyone can make an application, that will be a public document and public access is permitted, and that the role is played by the registrar. Then 130E deals with registrar to issue directive instructing the company to comply with 130A within 7 days. Company should it's a registrar's role, company to comply within 7 days. So it's very easy in E that 7 working days given to comply with. Then F deals with the claim for beneficial ownership not recognized unless disclosed. Now this is very important. If any shareholder or a foreign body or whoever is refusing to give information, you have taken all steps, the company has taken all steps, and if the registrar has taken all steps, due care taken, and if the CDS has taken all steps to get all these details, and someone is not giving, he or she might run the risk of not having any power of those shares. You may not have the right to the recognized, claimed or recognized as a shareholder. So that is something very important. I am sure the expert from the CSC will go into details of that. So 130F is something to be taken into consideration for the shareholders, corporate shareholders, individuals. If you don't comply with this, well, these are the risks you may run. Then 130G is basically the penalties for non-disclosure and non-compliance with 130A. So that they will be guilty of an offense. So that is the company, director, secretary, officer, shareholder. You have to fall in line with all the responsibilities and divulge these maintained and for transparency purposes. Then 130H, existing company shall provide details of beneficial owners to the registrar, which one deals with within 6 months. It's a role of the company. Within 6 months from the act's effective date, you have to do that. Then 2 deals with to inform the registrar as to shareholders who hold more than 10% of the issued shares. That has to be done within 30 days. Now that is for this CDS. Every depository is the central depository system we have. So their role, I believe, the expert from the CSC will say how and when and mechanisms they have and problems they would face to inform the registrar as to shareholders who holds more than 10% of the issued shares. I know in banks you can't, there is a regulation, you can't hold more than 10%, individuals can't hold, but in that is why that other regulation I mentioned earlier. But in CDS, in the listed companies, the CDS will, it is not an easy task, but she will have to venture into that when in she made presentation. Then 130H3, to verify, report, record and notify the registrar details of beneficial owners on the date of operation of the act. So company, now within 30 days, the timeline is that the company is responsible to do that. 130H4, penalties is found intervening in contravention of the provisions. 130H, you have 1, 2, 3, 4, 5. Existing company shall provide details of beneficial ownership to the registrar. Again, the responsibility is on the company within 6 months from the act's effective date. Then to inform the registrar as to shareholders who hold more than 10% of the issued shares. Every depository within 30 days. To verify, report, record, notify the registrar details of the beneficial owners on the date of operation of the act within 30 days, again for the company. Penalties if found guilty contravening the provisions. Definition of former written law related to companies. Well, all the old laws will come into operation. The companies get created by the old laws. Then 130I, regulations to be made by the minister. Now, minister has to come up with this regulation. I believe that is they are going ahead with this, and I believe the minister will have to give these, make these regulations as early as possible. Then 130J, I mentioned about the interpretation of beneficial owner and effective control. That covers 130A to J, which is important with regard to the effectiveness of this. Now, unfortunately, so far we have not had the regulations and the forms in place. The Registrar of Companies will mention more about this aspect. Until the forms, I will be, under the Companies Act, there are 534 sections, 46 forms and 13 schedules. Now, 46 forms are specific, they are prescribed forms. So there are a couple of forms referred to in this. So those have to be in place to do it. But I would say, in an abundance of caution, all these companies, you go look at the deadlines, see and get going now itself. Don't wait till the because we are only starting this process at I mean, this is the first time it has come in. We are only still in September. Act came into operation in August, 4th of August. And this is a good transition period, not to wait till all the other things happen. I believe it will happen sooner or later within this year itself. And it is best if companies, the directors, the shareholder, the company secretary, senior officers, then again couple of actions by the shareholders, then also the regulator CDS, and basically the Registrar of Companies. So it's responsibility cast on the company secretary as an individual, responsibility cast on the Registrar of Companies and the CSC, and they will have to deal with this particular additional burden which has been brought in, how best it can be protected. I mean, we are falling in line with international mechanisms, and we have no choice to say that we are not going to do it. They say, well, investors want to know whether you have all these protections in place. And it has been a very common practice that black money becoming white through corporations. So the idea is good, the belief that we will have a better transparent mechanisms of all these as we go forward. Well, it is not easy. I won't say it will be an easy task, but as we go along, maybe the companies might get used to it, the actual players might get used to it, and I hope and pray that all these players I referred to responsibility cast, and they would have a fair amount of understanding of these particular amendments which has come in with the 12 of 2025, which is of importance to the corporate world and the corporate landscape of this country will be better managed and a proper level playing field, and also transparency in most of the matters. How effective it would be will depend on the way you deal with and how best this can be dealt with as we go along. Thank you very much.
Thank you, Dr. Cabral, for the detailed review of the Companies Amendment Act number 12 of 2025. Building on that legal framework, let me take a moment to show how we at Deloitte Corporate Services is approaching this most critical aspect of the Companies Act. Definitely, the beneficial ownership disclosure. We call it this as Green BO flow. It makes compliance not only a legal requirement, but also transparent and sustainable process. Interesting? Let's have a look.
Hi everyone, I'm Nilushi and this is my colleague Aisha. Today we will share Deloitte's perspective on the beneficial ownership disclosure and explore how digital tools can make your compliance journey smoother.
That's right. With the 2025 amendment to the Companies Act of Sri Lanka, every company must maintain a register of its beneficial owners. At Deloitte, we are planning to use technology to meet the new legal requirement for beneficial ownership disclosure. By this, we are not just staying compliant, we are building more transparent and responsible business.
Yes, the amendment requires every company to maintain a register of beneficial owners with accurate identity details such as name, date of birth, nationality, address, NIC number, tax identification number, which is the TIN number, contact details, and ownership information. The aim is transparency to deter money laundering and other financial crimes by identifying the real owners behind companies.
At Deloitte, KYC process is already in place for conflict check and risk management purposes. Deloitte, being a designated non-financial business or profession, conduct customer due diligence for all its clients, and risk indicators apply, like complex structure, high-risk jurisdiction, or when politically exposed persons involved. Therefore, maintaining a beneficial ownership information is an addition to these compliance checks.
Yes, Aisha. So now we are planning to share an updated KYC with beneficial ownership details with our clients, where clients must provide information along with certified verification documents such as NIC, passport, and address proof. You might think how automation plays a role. Here's how. It's a SharePoint-based automation process which we call as Green BO flow. We send standardized KYC forms to capture beneficial ownership details. If any information is missing, SharePoint automatically detects it and sends a follow-up request to the client. We use the central bank's FIU sanctions screening tool, planning to run NIC verification via the Department of Registered Persons and verify the documents. Based on verified beneficial ownership details and screening outcomes, clients are classified into risk levels. Verified data of beneficial ownership is extracted into a digital register. Records are retained for 10 years in a cloud storage as required. Access is role-based. to support Personal Data Protection Act compliance.
So, is Green BO flow a one-time process?
No, we are not stopping at that. Along with our annual KYC review, which is in place, we are planning to obtain updated beneficial ownership details via the automation process. Apart from that, SharePoint triggers reminders for clients to confirm or update beneficial ownership, and whenever we are informed by our client regarding a share issue, share transfer, or shareholding involved group restructuring, our team updates the event in SharePoint, which automatically requests a fresh KYC with an update on beneficial ownership. This is a demonstration of our Green BO flow. The Green BO flow begins when an event is triggered in the MS list, such as client onboarding, share transfer, and share transmission, etc. Immediately, an automated email is sent to the client requesting the necessary KYC and BO forms. Once the client receives the email, they are expected to fill out the required details and reply with the completed forms. If the submitted forms are duly filled, the person in charge receives a confirmation email indicating successful submission. Afterwards, verified information is securely extracted and saved into the BO register with limited access in line with PDPA. This flow automatically detects partially filled forms and sends email to the client requesting corrections.
So, Nirushi, this isn't just ticking boxes. It's a core element of good governance, and automation is the smartest way to manage it. While understanding the importance of these, Deloitte is taking a proactive approach to identify the risk level of each client based on their shareholding structures for internal purposes. Companies with direct beneficial ownerships are classified as low risk. Companies with indirect beneficial ownership with two layers are classified as moderate risk, and companies with complex and layered beneficial ownership and or with politically exposed persons involved are classified as high risk. According to risk levels, our surveillance differs, such as collecting updated beneficial ownership details on a quarterly basis for high-risk companies. We believe that this approach helps our clients to comply with the legal requirements. In this context, Deloitte views this beneficial ownership disclosure through environmental, social, and governance, the ESG lens. For environmental, reducing carbon emission with no use of paper. For social, protecting individual right in line with personal data protection. For governance, increasing public disclosure to ensure transparency.
Yes, absolutely, Aisha. With that, we are turning a regulatory requirement into a governance advantage and a sustainability win. The new Amendment Act has raised the bar for corporate transparency. But with smart automation and a strong ESG mindset, compliance becomes a strategic advantage. Now onwards, any changes in shareholding structure, you will need to pause, think, respond. This is how we are going to reform today
for a resilient tomorrow.
That was a glimpse of how Deloitte navigates these reforms. Now, as a next agenda, we'll see how capital market is going to respond. To explore this, we are honored to be joined by Ms. Shivandini Liyanage. Ms. Shivandini Liyanage is a Senior Vice President, Legal Enforcement and Compliance at Colombo Stock Exchange. She is an attorney at law, notary public, and company secretary with 19 years' experience in the legal practice. She is highly skilled in corporate and regulatory compliance, developing policies, procedures, rules and regulation, corporate governance and enforcement. Ms. Shivandini Lenage will share how is Colombo Stock Exchange is getting ready to respond this Companies Amendment Act number 12 of 2025. Ms. Shivandini, over to you.
Thank you. Good afternoon, everyone. I will be discussing CSE's role in implementing the Companies Amendment Act. Section 130H2 specifies that every depository is required to verify, report, record, and notify the registrar within 30 days from the date of the operation of the Act details of the shareholders of a company who held 10% or more of issued shares of that company as at the date of operation of the Act. Now, as we know, the regulations are still to be gazetted and the date of operation of the Act is still unknown. The details of the shareholders is also not specified under the Amendment Act. We're hoping that the regulations will shed some light of the information that is required, and the company registrar forms, which is also yet to be gazetted, should share some light on it. We are made to understand BO Form 6 is the form that the Registrar of Company is intending to collect information under 130H2. So once we see the regulations and these forms, there would be much certainty of the type of data that CDS needs to collect and report to the registrar. Identifying the beneficial owner in certain circumstances can be a daunting task. Foreign funds, unit trusts, companies with complex shareholding structures, and even trusts, for example, finding the natural person is very challenging. The obligation of CSE under the Amendment Act looks to be a one-time requirement. As a facilitator, CSE is in consultation with the regulators to actually understand their expectations and the requirements for compliance under this Act. The CSE is a regulated authority, and any substantial changes to the rules or any other changes that are of magnitude requires the regulator's consent and approval. However, these are a few areas, possible areas that changes are expected, and we are hoping to ensure compliance by looking into these areas. Please bear in mind that this is not an exhaustive, complete list by any means. Based on the necessity and the requirements, these could vary. We could look to develop guidelines for brokers, trading participants, depository participants, and custodians on collection of information from their clients. Actually, custodians and brokers are our focal points. They are responsible for collecting data of their customers. filling out KYCs, conducting customer due diligence, and so on. We can also give them guidelines on updating the existing data that they've collected to match with the information that is required for reporting. And of course, data verification. There are certain documentation that will be taken by their clients at the onboarding, and these documents can be used to verify the data that they collect. We could also possibly look at introducing disclosure requirements at identified trigger points. The trading participants, the brokers, and the custodians may obtain self-declarations from issuers and from their customers. We can also maybe look at possible rule changes depending on the frequency of reporting if it changes as time goes by. These rule changes, as I mentioned earlier, will be of course under the guidance of the regulator and with the concurrence and their consent. We could look at probably making changes to the trading participant rules and the CDS rules, and of course the internal guidelines of CDS, in order to ensure that the proper data is collected, and also to continue operating with the CDS account, we can make certain data mandatory so that that data will be collected and verified and will be with us. We could also look at possibly calling for additional information in your listing applications. Information regarding company structures, UBO disclosures, and so on, to maintain transparency. And most importantly, I think we need to look at internal processes and guidelines, our systems, and our applications to make sure they align with the requirements of compliance. How should companies prepare? What should companies do? Companies should also have suitable internal controls in place to identify the BOs. High-risk customers and entities, you should try to implement enhanced due diligence, monitor indirect holdings, layered structures, and change in ownership. You could also use authentic screening and analytic tools to implement ownership mapping logic. Again, most importantly, you need to train your staff to identify, escalate, and monitor and report beneficial ownership requirements. Thank you.
Thank you, Ms. Shivandini, for valuable perspective. Next, we see how Registrar of Company, the key player of this Amendment Act, is planning to enforce. For that, we are honored to be joined by Ms. Shama Hashini. She serves as Deputy Registrar of Companies and is an attorney at law with expertise in corporate law and governance. Ms. Hashini continues to play a crucial role in shaping corporate regulatory landscape of Sri Lanka. Ms. Hashini, over to you.
Good afternoon, everybody. Now we will see how these beneficial ownership concepts apply to ROC and how do you comply with these regulations with ROC, the Registrar of Companies. Once this act come into operation, you have to, every companies incorporated or registered in Sri Lanka have to adhere to these rules. There should be an authorized person in this each and every company, and that particular person should get all the data of this beneficial owners of the company. There are 7 forms which scheduled to be gazetted, called from BO1 to BO7. Then each and every instance, you have to file these forms through online. You have to submit through online to the ROC with prescribed fee. We will regularize, we will gazette the fee structure through the regulations. With that prescribed fee, you have to, within stipulated times in the act has mentioned the stipulated times, within stipulated time with prescribed fee, you have to submit these forms through online. Then ROC will register these forms, and according to registration, this our beneficial ownership registry will be updated. Then from this beneficial ownership registry, the authorities like Attorney General, FIU, Customs, IRD, public procurement authorities, and regulatory authorities, and any public authority having the responsibility for investigating or prosecuting money laundering, terrorist financing, or any other criminal offences can get details of the beneficial owners of the company under section 130B. We can release data to the general public also under section 130D, but that will be restricted. We will be release only the data, full name, previous full name if any, nationality, country of residence, business address, and full statement describing the nature and the extent of the beneficial ownership. Those are the details we can release to the general public. But there's another instance, even public can ask for a rest of the other data also. When they request for a data like date and place of birth, last known address, residential address, email address, postal address, national identity card number, tax identification number, passport number, or contact details, then we will see the Right to Information Act number 12 of 2025. In that act, the section 5 says denial of access to information. If those requests does not follow under this section 5 of the Right to Information Act, we'll release the data. If not, we won't release the data. Very soon we'll publish the regulations. The ministry will publish the regulations. In that regulations, we will mention 7 forms. One is BO1, Notice of the details of beneficial ownership of a company to be delivered to the registrar at the time of incorporation or registration. So at the time of incorporation or registration of a company, together with rest of the forms, you have to submit this BO1 form too. BO2 means notice of the details of the beneficial ownership of a company to be delivered to the registrar at the time of issuing of shares of the company. Then BO3 means notice of details of beneficial ownership of a company to be delivered to the registrar at the time of transferring of shares of the company. Then there should be an authorized person. Then BO4 means you have to inform the appointment of an authorized person, as well as if there's any subsequent changes, you have to inform us through BO4. BO5 means notice of details of beneficial owners to be delivered to the registrar together with the annual return. Together with the annual return, you have to submit BO4. BO5 form also. BO6 means notice of reporting receiving details of beneficial owners of the company. So once date of, from the date of operation of the company, you have to give the beneficial ownership details of the existing companies. 130, then if you, when you see this slide, from the date of operation, within 3 months' time, each and every company incorporated or registered in Sri Lanka have to notify the registrar who is the authorized person of this each and every company. Within 3 months' time, you have to file, submit online BO4. Then within 6 months from the date of operation of the Companies Amendment Act number 12 of 2025, each and every company has to inform the registrar who are the existing beneficial owners of the company within 6 months. Within 6 months, you have to inform who are the beneficial owners of the company. Within 4 months, you have to inform who is the natural person as the authorized person of this company. Even before that, the deadline is 6 months. Before that, you can inform through online the details. That most of them are asking about this 130H3. 180H3 means some of the companies, even in our present EROC system, the provision is there to mention who is the beneficial owner, who are the beneficial owners of the company. Some companies have mentioned that who are the beneficial owners, already they have mentioned. Such companies comes under 130H3. So that such type of companies has to mention within 1 month's time through BO6 form who are the beneficial owners company. That's for the companies who have already mentioned the beneficial ownership details to the ROC. And there's an 130H2 applies to the every repository of a licensed stock exchange. That they will give us no need to file forms. They will give. There will be a system for them to give us the details of all these stock exchange listed company details of the beneficial owners. From the date of operation of the Companies Amendment Act number 12 of 2025, when you incorporate a company or registered a company in Sri Lanka, together with other documents, you have to file BO1 form and BO4 form. BO1 means the details of the share, the beneficial owners. 4 means the authorized person details. Then after that, there may be changes to this given details. Then if there's a change of the authorized person, then again you have to file Form 4 within 10 working days from the date of change. Then there's any change of issue of shares under 130A1 or 130A10, then you have to file BO2. If there's a share transfer and change the beneficial ownership structure, then you have to file BO3 with ROC. That BO2 and BO3 forms to be filed within 20 working days from the date of change. The form BO5 to be filed together with the annual return. Each and every year, together with the annual return, you have to file BO5. Then there's a form called BO7. This form to be filed, if there should be share registers, there should be a place to keep this beneficial ownership register also. If there's any change of this location, then you have to inform this to Registrar of Companies through BO7. Thank you.
Thank you, Ms. Hashini, and thank you to our speakers for setting the stage. We'll now move on to the last part, the webinar, the panel discussion, where we try to bring together diverse perspectives on how the Companies Amendment Act number 12 of 2025 will reshape governance, compliance, and business practice in Sri Lanka. Joining us on this panel are Dr. Harsha Cabral, Ms. Shivadri Liyanage, Ms. Shama Hashini, and this panel discussion will be moderated by Ms. Disna Pereira, Director of Corporate Secretarial, Deloitte Sri Lanka and Maldives. Ms. Disna, over to you.
Good afternoon, everyone. It's real pleasure to welcome all of you to the last segment of the webinar today. We are honored to have such a distinguished panel with us. Before we begin, just a little housekeeping note. If you have any questions to raise from any of the speakers, please use the Q&A feature in the Zoom platform. Type your question very briefly and send it through, and we'll try to accommodate as much as possible. Okay, so let's dive into the questions. We all know by now the most significant change introduced by the Companies Amendment Act number 12 of 25 is the beneficial ownership disclosure requirement. So I take the liberty to open the discussion today by focusing the beneficial ownership disclosure requirement, its practical aspects and implication. And my first question goes to Dr. Harsha Cabral. So we all know Section 130J defines the beneficial owner as the individual who owns 10% or more in a company, or a person who exercises effective control. This question has two parts. First part of the question is, so in case if there are multiple layers in a company shareholding structure, and in one of the layers, the majority shares are held by either an investment fund or a unit trust, is it correct to apply effective control to determine the beneficial ownership? Part two of the same question is, what constitutes the effective control? Particularly, it shall not overlap with the General Authority Act in terms of the Act. Over to you, sir.
The question of effective control is now when in the Companies Act, we have the director's role, and the director is defined in a very, very wide manner. So even if with the control test arises there, if you look at the definition in section 529 of the Companies Act, defines a director. There again they have brought in, which was not there earlier, but when we brought in the effective control, there can be some person who is not a director under the form registered with the Registrar of Companies, but the only person who is controlling that company, who is sort of a country manager. So if that role fits him, he is taken over as a person who controls. The normal control test in the labor law also has an impact on this. But the beneficial 130J defines beneficial ownership and effective control. Now, beneficial ownership arises with 10%. Now, whether anything more than 10%, whether you have effective control is a matter that has to be studied vis-a-vis that company alone. Sometimes there may be situations where there are shareholder agreements by which a particular group can control even if they are in the minority. So you have to look at the background and see how effective. Generally, if you have majority shareholding, say if you, for example, if you have 60%, you might have 4 directors on the board, and for the 40% you may have 3 directors on the board. So effective control is always with the people, the 6. So board control is there, shareholder control is there. So, but there are other mechanisms also where you can have effective control. So those are the issues which will be looked at case by case. So that is something that has to be looked, I mean, very, in normal companies, well, you know, if you have more than 50%, you can pass ordinary resolution. If you have 75%, you can pass a special resolution. If you have 85 or more, you can have you can pass a circular resolution. So those are inbuilt in the Companies Act, but the effective control mechanism will depend on company to company.
Thank you, sir. So I'll now move to Shivandini. Shivandini, now you took us through the areas that the Colombo Stock Exchange is looking at to review, to align the regulations in line with the beneficial ownership disclosure requirement. Now the Act requires one-time disclosure by the Central Depository System. It says the Central Depository System shall record, verify and report details of shareholders who are holding 10% more of issued share capital in listed companies. Again, there are two parts, Shivandini. What are such shareholder information that the CDS is going to report Registrar of Companies? Part 2 of the same question is, do you have a mechanism to verify such details?
Yes. So as to the details of shareholders that we need to report on, we are hoping the regulations will shed some light on the type of data that is required. Also, the company form BO6, I believe, would specify the type of information required. So once it's gazetted, we will see exactly what the data is. On the second part of the question, my answer would be the data currently is collected by the custodians and the brokers. And how you verify the data is there are certain documents like the NIC copy, the passport copy, the birth certificate, and the utility bills that we collect in order to verify the names, the residential addresses, and details that is required under the birth certificate, that is also required under the BO information collection. Using this documentation, we could verify the data that is available.
Thank you, Shivandini. Now, my next question goes to Ms. Shyama Harshini. Now, in your presentation, you explained that you had done quite a lot of work with regard to the regulation and which are to be gazetted very shortly. And you are also in discussion with Colombo Stock Exchange, FIU, and maybe other regulatory authorities with regard to the implementation framework. My question to you is, would ROC take a consultative approach to discuss the practical aspects with other stakeholders or the interested parties like directors, company secretaries, compliance officers, so that you can get the practical aspects and some of the potential issues that we may encounter once it's implemented could be addressed at the initial stage? What are your thoughts on that, madam?
Yes, definitely we'll take consultative approach, or both locally and internationally we have started such approaches. When we talk about internationally, we have consulted the IMF and the World Bank, and they have go through our regulations and they have given their comments, observations. According to those things, we'll develop our regulations as well. And when we talk about the locally, we have a advisory commission, then the Ministry of Finance, Presidential Secretariat, and the FIU, CDS, CSC, like that. And again, we will there will be some sessions, awareness sessions with the directors and the company secretaries. Within that forums, we'll discuss about these forms and regulations with them also.
Thank you, Madam Harshini. That's very important. So now I have another question with regard to the penalties that are imposed for the non-compliance in relation to the beneficial ownership disclosure requirement. Now, we all know it's the obligation of the shareholder to provide the beneficial ownership data. Let's say if a company has taken all reasonable care to obtain beneficial ownership data, those have been verified. But later it's found to be false information or the shareholder has withheld some of the information. In such situation, the reasonable care that has been taken by the company to obtain and verify the data would serve as a defense. And again, there is a second part to the question. In reference to any decided case law, what is reasonable care which can be applied in this context?
Do you want me to answer? Yeah. First, I must add something for the first question you asked about the effective control, because in the question you have posed to me, you have asked about case law on that. There is a case decided in 2013, UK SC 34, Prest versus Petrodel, where this case relates to a lifting of the corporate veil, and it speaks about uncovering the real actors who are in effective control of the company. You know that unfortunately we don't have that type of case law. I mean, even after 2007, we don't have certain, the case law is very limited. So these are the ones that will come up in the future. And your next question with regard to exercising, the section says, provided, however, that no such person shall be deemed to be guilty of an offence if he proves that the offence was committed without his knowledge or that he exercised all due diligence to prevent the commission of the offence.
Yes.
So that is like, for offence, normal offence, you have to have the action plus the mental element, actus reus and mens rea. So that element of the your deliberate, that you took due diligence. Now that comes from section 89 as well, where you cannot act in a reckless manner. So that type of due diligence is envisaged in this section. But the case law is basically based on this, the duty of care business. So the duty of care cases are like, you have Henderson versus Merit Syndicates Limited, the 1994 UK case, House of Lords. Then you have Ray City Equitable Fire Insurance Company, which dealt with the subjective standard, 1995 case, Chancery 407. Then you have Norman versus Theodore Goddard, which dealt with the objective state, 1991, BCLC, Butterworth Company Law Reports case. And then you have Dorchester Finance Company, stemming 1989, again, Butterworth Company Law case. And they have Australian case, SIC versus Adler, number 3, 2002, 168 FLR 253, again dealing with the duty of care aspect. So that is where the onus is on the directors to establish that they took all due care, due diligence, and they have gone out of the way to do it, and still if you can't find anything, well, what do we do? So they have exercised. But the most important thing of this non-divulging details of those, and if someone is hedging to give the actual details that are required, the main issue would be that person, the shareholder, will run the risk of losing the rights attached to the shares. Maybe voting, maybe attending, and maybe other rights. Maybe another shareholder might go to court, and even if the Companies Act, the registrar, the company is not taking any action, well, there will be a competitor who will come and say, well, that particular 15% details are not given. You have no right to vote on it. Or so you run a risk of losing your rights if you try to. I mean, if everything is clear, transparent, why not you give the details? But if you have a company, then that company is owned by another British Virgin Island company. That British Virgin Island company is owned by, well, another trust company in the US. The trust company owners are, the trustees are in Canada. So these are the issues. I believe it's a tough job for the regulator. Well, there'll be a lot of teething problems in divulging, getting details, so on and so forth. But I believe the systems will come into play as we go along.
Thank you, sir, for your very insightful explanation. Shivandini, now again I'm referring to the same section in the Amendment Act, which requires the CDS to provide the shareholding details of shareholders who are holding 10% or more of issued share capital in listed company. Now we all know there are companies where there are shareholders who are holding share balances in both CDS as well as ledger. And the CDS does not have a visibility of the ledger shareholding. But when you amalgamate the two shareholding, it can cross 10% shareholding. So how do you expect to overcome this challenge?
Correct. So CDS can be responsible for the data in the CDS system. What is outside our scope, what is within the control of the company secretary, the share ledger, is beyond our authority, and there is no way that we can reconcile or authenticate that. From our records, we gather that the discrepancy of having a share ledger and the CDS account is of about 4%. But that problem persists. So we'll have to look at a way where both parties are transparent enough and disclose, and then monitor it very carefully and then catch those. But currently it has to be a manual process because two parties are involved. And obviously transparency in disclosure is key.
Yes, we understand there are a lot of challenges to see Colombo Stock Exchange. Madam Harshini, now since you are done most of the drafting the regulations, what time frame are we looking at for the full implementation? And will there be any transitional period for the companies to adapt to these new changes?
Yes, we most probably will gazette these regulations. Minister will sign the regulations before 1st of November. Now we are in the process of developing our system, EROC system, to enhance these beneficial ownership requirements. Within, before 1st of November, we'll gazette these regulations.
Okay, thank you for that information. So again, now this term beneficial owner is not new. It's already in the Companies Act number 7 of 2007. For example, in section 198 under relevant interest, the term beneficial owner is mentioned. But it's not defined in the Companies Act number 7 of 2007, but it's very comprehensively defined in this Amendment Act in section 130J. My question to you, sir, can this new definition in section 130J be applied retroactively to any mentions of beneficial owner in the original provisions of the Companies Act number 7 of 2007?
Yeah, this act came into operation the amendment comes into operation in 4th of August. But if you look at 130J, the beneficial owner, it specifically says 130J under this heading, and then it describes who a beneficial owner is. So you can't have two definitions of beneficial owner in the same act.
Okay.
So unless this specifically says this applies only to this section, 130. So for that purpose, beneficial owner going forward will be, so it won't be retrospective, but after this act came into operation, this is the interpretation of beneficial owner, because the main 130 deals with beneficial owner, though it's not defined in 529 definition, but you have a clear definition. Now, for example, if you look at the shareholder, it's in a section, right? Yes. So it won't come up in the definition, but this will be applied going forward to a beneficial owner is.
Right. Thank you, sir. Shivandini, now we all know when a shareholder or group of holders acting in concert cross 10% shareholding in a listed company, under Takeovers and Mergers Code, they had to make a disclosure requirement to the Colombo Stock Exchange within 2 market dates. If I say, if the Colombo Stock Exchange in its review of the regulation, if they can request such disclosure shall include a statement to state that the shareholder has disclosed the beneficial ownership disclosure information to the board of directors of the listed company, similar to director dealings where it's required to notify the board and it's also part of the disclosure. Would it make sense for the Colombo Stock Exchange to bring in such change so that it brings us a additional mechanism for us to track BO data? Also, the shareholder is also aware that he has to submit the beneficial ownership data before he enters into the transaction. What are your thoughts?
Yes, actually, that's a very good idea. It's a possibility that we can look at. Yes, I think so.
Okay. Now, Madam Harshini, now we all know when there is a delay in filing statutory forms, ROC charges compounding charges for the delay. So if there's a delay in filing BO forms, will there be compounding charges?
Yes, there will be compounding charges. Now, presently, for a Form 20 per month, delay for a month, we are charging only 500 rupees, and maximum is 25,000 rupees. And other forms, other than Form 20, we are charging only 250 rupees per month. But for these forms, from BO1 to BO7, their charges may be higher than that.
Okay, thank you. And we have got some of the questions through our Q&A feature. So now in my first question, there was one first part, it was not addressed, and now same part has come in as a question as well. Now the question is, if a majority of the shares are held by unit trust or investment fund, whether the effective control can be used to determine the beneficial ownership.
As much as possible. Now, this is the introduction of a amendment. It will take a while for them to stabilize and see how far you can go. I mean, if you can't, I mean, even right now you will find, if you, Registrar of Companies will say, when the company secretaries will say, sometimes owners are dead and gone. Then you very difficult to find the heirs, and some have gone abroad. So up to a point they can go. And how long can you keep on chasing and find?
Yes.
So this is not really to go for transparent issues like that. This is to, that's why I said the objective of this amendment, or objective of this business beneficial ownership concept coming into the corporate world is to slightly move away from that corporate veil decision I was talking about earlier, where people were more honest at that time, especially the corporate world. The corporates were also more honest at that time. I think when we talk about Salomon versus Salomon, no one was talking about black money, to make white the black money. So as we go along, regulations come to ensure that you catch the wrongdoer. So you go up to a point. I mean, yeah, it's very difficult. That's why I say, I mean, especially for the listed companies, it will be very, very difficult to understand. I mean, locally you might be able to get, if it's even is a trust or a association or whatever who owns, or the estate of some person who are the heirs, okay, those details you can get. But the true beneficial owner, how long, the detailed route of getting to the correct owner is a tiresome job. So, I mean, the companies may try to do it, mechanisms of such, and even the true owner will have to be, they must have abundance of caution to safeguard the rights of the share. So, I mean, no point in having a share if you can't exercise any right on that. So, these are the two issues you've got to look at. It won't be easy, but there will be a lot of teething problems in locating these people, getting the details, but and the repercussions will come. Okay, they might run to court and say you can't get details. There will be court litigation on these issues. So we will have to see what the teething problems are, and accordingly they might have to. But the best thing is for them, as I think the regulators, the Registrar of Companies and the CSC both will be taking assistance, getting assistance from the international organizations like the IMF and World Bank and certain other organizations. And Central Bank, FIU, this came in 2018 for the banks. So even the effective control is mentioned there in that particular guideline. That is the first time we looked at effective control. So these have to be time tested. Maybe litigation might come on and we'll have to see how it goes. But the idea of transparency is good for corporate governance. So ultimately, how far they can go is another issue, and that is where the international organizations will have to assist the regulator, the ROC, and also the other regulators to ensure. I'm sure central bank has got it right to a certain extent, because now they are almost 7 years in the game. How to establish, in banks, KYC is a must. You must know who your customer, know your customer is an important matter in the financial sector. So most of these things come well tested there and then get onto the company. So, well, only time will tell how successful we would be.
Yes. Thank you, sir. Madam Harshi, there's a question from one of the participants. The question says, can these BO1 to BO7 forms also be allowed to any third party to peruse through a file search of a company through the eROC login?
No, they can't. We are giving only the details I have mentioned in my presentation, only that details we are giving, not the all details. We are not issuing the certified copies of all those forms.
Okay, understood. Thank you. Dr. Cabral, there is another question. This is regarding the liquidations. When the liquidator gets various complex liquidations, very often no two liquidations are the same. So how does the amendment to section 341 balance deterrence with liquidators' practical challenges?
Refer to 341.
Yes.
Actually, 341 amendment is a very, very minor amendment. It is only the word subsequent has come in for the word later.
Okay.
Right? And the liquidator shall send to the registrar a copy of accounts and shall make return to him confirming the facts on holding. So this is giving more flexibility for the liquidator to act. There is no change in the liquidation process.
Okay.
But I must say that now that the question has been raised, our liquidation process is totally archaic. Our winding up rules are based on the 1938 rules. So between 19, that is almost how many years now? So we have to change our winding up rules, and there is, now it's in place. It will become a bill very soon. Large chunks of our winding up sections will be removed, and more or less a proper insolvency regime will come in. So here the liquidator's job is basically as an undertaker's job to give a decent burial. You collect the assets and liabilities and, close shop. But 341 has not changed, but you don't have to worry about 341 because all these things will come in the new area. But he is only giving more leeway to the liquidator, which is the time frames and things like that. But overall, the liquidation mechanism has not changed with this amendment. Right? Other than that, that's why I say liquidation whole process has to be rehashed, because I'm sad to say that, even in the courts, I see most of the younger lawyers making all sorts of applications regarding liquidation, because without even looking at the rules. So you can't go to court and talk about liquidation or file a petition to liquidate a company, whether it's a creditor's liquidation or a member's liquidation or a voluntary liquidation. Rules are very specific. Very few have understood the rules. Very few have read the rules. So unfortunately, all sorts of orders are made on this. So anyway, liquidation is one area, because we don't have Chapter 11 of the US. We don't have the Janahartha model of Malaysia. So we don't have the Sikh Industries Companies Act of India. So liquidation area, winding up per se, has to be structured, because we don't have business recovery as such.
Okay, thank you, sir. Now, since we are running out of time, I'll have one question each from three of you. First, I'll start with Madam Harshini. Now, we know Registrar of Companies is going to be the central custodian of the central BO register. And some of the beneficial ownership data are confidential, personal, and sensitive. And we have a Personal Data Protection Act in place. From the registrar's perspective, would you be able to give guarantee that the necessary data protection aspects are being looked at when you implement the BO register? Because it's very important, because shareholders should know that their data are safely handled in terms of the provisions of the Personal Data Protection Act.
Yes, of course. We'll protect the data of the beneficial, the shareholders and the persons who have effective control also. Data protection is what we will adhere to the data protection laws. And within the ROC also, we will protect the data without releasing these things within our staff also. We are in the process of implementing a process to secure this data. Therefore, nothing to worry about giving the correct data to ROC.
Thank you, Madam Harshini. Thanks for that assurance. Shivandini, now when this act was enacted, there were negative comments as well as positive comments. From the CSC's perspective, do you see any setback in market activities or foreign buying once the regulations are in place?
It shouldn't. Regulation and compliance should complement the economic objectives of a country. And investors should respect good governance and transparency. So ideally, it shouldn't. But as we all know, market is manipulated, and there'll be different reasons could make the market act in a different way. But ideally, as time goes by, because this concept is worldwide, UBO, declaration of UBO, transparency is now adopted in most of the countries. So I think we are a little too late to introduce these into our laws. So I sincerely hope it wouldn't.
Okay, thank you. Dr. Kabra, this is the last question, but it has two parts again. Looking at the BO regime in the region, do you think anything could have been done differently in this legislation? The part two is, do you see this BO legislation as a deterrent to new investments, or rather positive move to bring transparency and good governance?
Well, there are two schools of thought. Sometimes people say too much regulation is bad for growth of economy or the corporate world. But unfortunately, in certain regions, regulation is also needed. I always say that without regulation, we cannot go forward in certain jurisdictions. You don't find very honorable people now. Majority of the people are not honorable. So it's very long years ago, courts didn't want to interfere in internal management of companies. But that was 100 years ago. And now it has changed to a certain extent. Unless you're regulated, well, you may not follow the correct path. So internationally, this has happened. Now even corporate governance came with the Cadbury Code in 1992. And only in 1997, we picked it up and we came up with our own code of best practice. So like that, it took a while for us to pick it up. But now there is pressure from these donor agencies, World Bank and a lot of other institutions. So that's why it was earlier introduced to the banks, FIU. And I believe going forward, transparency is important. Proper corporate governance mechanisms are important. So we have little choice in the matter. And maybe these investors also might ask these same questions. Have you followed this? Have you followed this mechanism? Do you have the best corporate governance practices in your jurisdictions? Well, in that way, it will be a plus to have it. But getting used to it, it will be rather difficult. But as we go along, we'll get used to it. Now, people don't drink and drive in the evening. 10 years ago, it was not the case. So regulation has worked.
Okay. Thank you so much. Thank you for all three speakers for taking your time and be with us today to share your insights with us. To quickly recap the today's session, now we all know Companies Amendment Act has introduced significant change of beneficial ownership disclosure requirement, while others are to bring clarity, transparency, and maybe correction of certain typographical ambiguities. The message is clear. The governance requirement, the bar has been raised for the governance requirement. So the companies must quickly adapt to these changes. Leveraging the technology is very important so that the companies will be able to mitigate some of the risk, and also they will be also able to comply with requirement with less burden. I hope all of you had great time and some insights that you can take back to your team. Before we wrap up, the recording of this session will be made available to all of you who joined the session, and we will be also sharing the feedback form, and appreciate if you can take few minutes of your time to share your feedback. I now invite Nilushi Vijayasinghe to deliver the vote of thanks. Thank you.
Ladies and gentlemen, as we draw this insightful session to a close, I'd like to extend our heartfelt gratitude to each of you for being with us today. A special thank you to our distinguished speakers, Dr. Harsha Cabral, President's Counsel, Chairman of the National Savings Bank, Ms. Shivandini Liyanage, Senior Vice President, Legal Enforcement and Compliance at the Colombo Stock Exchange, Ms. Shyama Harshini, Deputy Registrar at the Registrar of Companies, and of course, our moderator, Ms. Disna Pereira, Director, Corporate Secretarial at Deloitte Sri Lanka and Maldives. Your expertise and perspectives have truly illuminated the practical implications of the Companies Amendment Act number 12 of 2025 and its impact on governance and compliance. We are deeply grateful for the clarity and depth you brought to today's session. To our valued clients, colleagues, and all interested participants, thank you for your engagement, your thoughtful questions, and your commitment to staying ahead in Sri Lanka's evolving corporate landscape. We would also like to extend our sincere appreciation to our leadership, Mr. Channa Manoharan, Country Managing Partner, Deloitte Sri Lanka and Maldives, Mr. Gerard David, Deputy Country Managing Partner, Deloitte Sri Lanka and Maldives, and Ms. Charmaine Tilakaratna, Head of Tax, Deloitte Sri Lanka and Maldives. Thank you for your unwavering support and for championing initiatives that empower meaningful dialogue and professional growth. A heartfelt thank you to our marketing, brand, and communications team for crafting the story behind this event, to the technology and transformation team for providing the necessary automation solutions, to administration team for their tireless coordination, and all other support teams, as well as the staff at Deloitte Corporate Services. Your dedication behind the scenes made today possible. We hope today's discussion empowers you to lead with clarity, resilience, and purpose. So until next time, stay informed and stay inspired.